Everyone. Thank you for joining us today, and welcome to the first of what will probably be several tariff and trade webinars hosted by eShipping. My name is Amy Hilger, and I'll be kicking off today's discussion on navigating tariffs imposed under the International Emergency Economic Powers Act and the effect of the Supreme Court's decision and what that has done to all of us on this call. We have two members of our eShipping International team here today to lead this discussion. First, we have Kristen Richardson, our Director of Customs Brokerage, and Chris Witt, Manager of Continuous Improvement and Compliance. So these two are wonderful people if you know them. They're an absolute wealth of information. They know customs brokerage and freight forwarding like the back of their hand, and we are very grateful for their leadership, their time, their expertise, over the past several years, frankly, as we navigate all things tariff related. So for today's webinar, you can see the agenda that's on the screen right now. And we're going to start with today we're going to start with the Supreme Court's IEEPA ruling that happened on February 20th. And we're going to focus specifically on the changes that have happened since. So we're going to cover the unknowns. We're going to cover the likely impact that you're feeling in your business. And most importantly, at the end of this, we're going to present to you some tangible steps that you can be taking now while we all wait out future rulings by the various, legal and government entities involved. So before we get started on the next slide, Chris, I wanted to quickly go over some housekeeping items. First, you'll notice that all attendees on this webinar have video and audio turned off, and that is to respect the privacy of our customers who are on the call. But please, please, please feel free throughout the duration of this webinar to submit any questions that come to mind. And you can do that through the chat feature in this webinar. So if you go to the bottom of your Zoom screen, you'll see the chat icon at the bottom of the screen, and just click that, type in your question. And then those questions will be visible to myself, Kristen, and Chris. And we've designated 15 minutes at the end of this webinar so that we can answer those questions live. So we look forward to seeing all the questions that you guys have for us. Let's see what's next. So what happens after this webinar? A link to this recording will be emailed to all attendees. And then if you have additional questions or concerns after we get through all of this, what are the next steps for you? So there's two things. For the eShipping customers on this call, the best thing for you guys to do is to follow up directly with your account manager. They are your point of contact. They are the people who can put you in touch with the right people, get questions answered. Go directly to your account manager and they will help you however needed. For the non-eShipping customers on this call, there's two things you could do. You could follow up with the salesperson who invited you to this webinar, or you can submit your question through a contact form. And I'm going to be putting that form link in the chat right after I get done talking. And so you can click that link, you can submit questions, comments, you can, if you want to get signed up to receive international updates each week, I send that through the form. If you want to receive our monthly industry update, you can also send that through the form. So just anything you need to communicate to eShipping, just feel free to use that if you don't want to reach out to that salesperson you've been speaking to. So let's see, a couple other items. Legal wants me to remind you that all information provided during this webinar is informational and advisory only. And we encourage you all to consult legal counsel for definitive and binding information. And then last but not least, please visit us on eshipping.biz. On our blog, that's where we house all of these international updates that come out each week from Chris. So that is a single place where you can go to access the many, many updates that we've been posting throughout the last 12 plus months. So I think that's it. Enough from me. I'm going to hand this over to Chris and Kristen so they can get started.
Hello, everyone. We really appreciate the opportunity to share the knowledge that we have here. In the beginning, we're going to kind of set the stage of what's currently happened, some of the, legalities of it, and then we will work to what we know you're all waiting for is the information of if there are refunds, how can we start working towards that goal. So, as we all know, on February 20th, we did receive a Supreme Court ruling that everyone was waiting to hopefully have those International Emergency Economic Powers Act tariffs to be overturned. And they did rule that President Trump and his administration did not have the ability under that act to instate those tariffs. So from here on out, if you hear me say IEEPA, that is the abbreviation for International Emergency Economic Powers Act. And the fact that I said it twice without stumbling, I'll clap for myself on that. So, but IEEPA tariffs include uh, the Chinese fentanyl, which was 20%, the Canada fentanyl, which was 35%, the Mexico fentanyl, which was 25%, and then the global reciprocals, which have ranged in many different values. The highest for China was 125%, and the lowest has been 10%. So anything that was referred to as a reciprocal is an IEEPA tariff. Also, the Brazil human rights violation, which was at 40%, that also was under IEEPA, so it was included in this ruling. And the India Russian gas, the Russian gas, Russian oil IEEPA that was applied to India due to their use of Russian gas, which I know have been overturned before this ruling came out, but all of those tariffs that were paid before that being, expired continue to be part of this ruling. So once the ruling was put in place, then the U.S. Court of Appeals and Federal Circuit needed to issue mandates to the Court of International Trade within 32 days. There was a petition that went out that was sent to the CAFC and was asked that they did not wait those 32 days. And as of yesterday, they approved that petition and they have issued the mandates to the CIT, or the Court of International Trade. This is great because this will expedite things and will allow them to start to regulate and put a process to the ruling and figure out what the ruling actually means for you all as importers. So keeping that in mind, this Court of International Trade is the governing body that has complete power in this situation. So it's not the Department of Commerce, it's not Customs and Border Protection, it is not President Trump's administration. All decisions are going to be made through the Court of International Trade. So they will be the ones who decide whether there will be refunds, whether there will not, and what that process would be. Now, notice I did note here that the Supreme Court, as well as the Court of International Trade, have listed other sections of trade acts that President Trump can use for instating duties. So it's not that he doesn't have the power, he just does not have the power under IEEPA, the International Emergency Economic Powers Act. So the other sections that he can instate duty, we have seen. We've seen sections 301. Those were instated in 2018. We have sections 232, which we've seen on steel, aluminum, timber. And then section 122, which I know we're going to talk about later in this webinar. And then there's a couple that he has not yet used, which is section 201 and section 338. And so the power is there for President Trump to use. He just was using an act that was not available to him. Now, there are other powers that are within the IEEPA Act that allows him to do a full embargo. So we've seen that recently with Spain. He's threatening to do a full embargo and not accept imports from them at all. That power is granted him, but the power to initiate individual country duties without Congress being involved. That was not within his power. Okay, so current status and outlook of the potential tariff refunds. The Supreme Court ruling did not directly address whether there would be refunds granted, or they did not even venture towards that area. They are leaving that for the Court of International Trade to be able to make that decision. So there's some good news that we can share, here and just later in this slide for the Court of International Trade that does indicate that they are considering those refunds. But the refund process could look very different depending on how they plan to put the process in place. Basically, we know in the past, traditionally, we've been able to use post-summary corrections for anything that was not liquidated, which is usually 300 up to 300 days after the clearance. We could use protests after liquidation, which allows us 150 days after that liquidation to submit a protest through ACE, and then the C, or an agent who has expertise in the area of your commodity, would review those protests and decide whether they would approve the protest or deny the protest. And there's also, thanks to the Court of International Trade, that anything that's outside of this 150 days to file a protest, Trade Council can file under 28 USC 1581I, which gives the Court of International Trade the ability to not pay attention to that 150-day protest period and grant refunds outside of that period. So that is a very, very good thing for the importer. Okay, so and then some encouraging news that I promised. In December of 2025, the Court of International Trade released a couple statements that really are great. The CIT has the power to order reliquidation or refunds if the government has unlawfully imposed duties. So we know that this is the case in this situation. The duties were instated unlawfully. So that is where, if it's outside of the liquidation period or the protest period, they are able to go ahead and file these court cases that will go along with it and be considered. Okay, sorry, needed a drink. I'm talking too much. Kristen, we need you to get in here. The CIT will retain jurisdiction over claims for refunds for a 2-year statute. That's important. If you have fallen outside of the protest period, you will need to file this within a 2-year period to be able to be considered with this case and to be able to receive those refunds. Okay. So, sorry. The process for the CIT to establish a refund process, for importers to file for that process, and for the refunds to actually go through the government backside of the financial side for you to receive those refunds, that could take months. It could take years. The Department of Commerce and CBP will have to participate in this. But as we know, CBP has been very cautious, and Kristen's going to talk about that here in a minute, but have been very cautious about participating in this process. And almost at times, it seems the Trump administration is being resistant to these refunds. He's even stated in a press conference that he will slow the refunds if he has the ability. So there's a lot of money involved. There's a lot of things involved. So I'm sure everyone is eager to receive their refunds. And they're also, on the other side, they're very hesitant about how to handle such a large task. there is a precedent where we can kind of see how this process might move that happened in the Court of International Trade, which was in 1998. There was a harbor maintenance tax that was ruled that it should not have been applied, and they did process refunds for it. That refund process did operate under 1581I, but it did take 5 years to be fully refunded back to the parties involved. We're hoping 5 years is not a timeline that we all have to abide by. 1998 was a very long time ago. I was wearing my jam shorts and, had my multicolored hat on at that time. So hopefully, just like fashion, we've all progressed in the ability to move things much faster. Some trade lawyers have speculated that the protest period and the ability to file those protests is going to be a big factor in this refund process. But again, the Court of International Trade has not released anything as to whether there will be refunds or if there will be additional processes that maybe we haven't seen before. So we don't want to jump the gun on saying what exactly will allow this. Kristen, I will turn it over to you.
Yay, it's my turn. So before we get into more of the refund process, I want to take some time to talk about what's happening now, what's happening in operations since the ruling. So as Chris had said, the IEEPA tariffs were ruled illegal on February 20th. So I kind of want to set expectations, the importer's expectations versus customs regulations. I know a lot of people on February 20th celebrated, as I did, that we kind of got the ruling finally saying, yes, the IEEPA tariffs were illegal. But as we quickly saw, it wasn't just to stop operations. IEEPAs are done being collected. Where's our refund? There was a lot that had to go into place for that to happen. So Customs came out with the executive order on the, I want to say it was like on the 21st or 22nd. So even as of the 20th, my team, we had even stopped thinking, okay, let's stop filing entries. Monday morning, we're going to wake up, IEEPA tariffs have been removed, and now we can just like move on with our lives. But that didn't happen, and it has actually not happened yet. So we do have a hard stop date of the 23rd. So IEEPA tariffs were and are still being collected up through February 23rd. The 24th is when the Section 122 went into effect, but we'll talk about those in a second. So just sticking with the IEEPA tariffs right now. So we were getting rejections. Customs would not allow us to file an entry that IEEPA tariffs were removed from, all the way up through or up to 11:59 on the 23rd. In addition to that kind of bad news, the date in question is actually when a shipment was in the United States. So that very first port, we're talking New York, LA. So if a shipment arrived on February 23rd, and even if my team doesn't file entry because it's moved inbound inland until say even March or today or later on, we still have to apply those IEEPA tariffs. That very first port is still dictating what if the IEEPA tariffs or the 122 tariffs go into effect. A little frustrating, I think, for the industry and for the brokers, just because they said it was illegal and we're still having to collect those tariffs. So especially shipping customers, if you're working with a different broker, you are going to get invoices and you're going to say, wait a second, these were illegal on the 20th. What are these IEEPA tariffs? That's the reasoning. Customs gave the hard shut off on the 23rd. And then the 24th was when Section 122 goes into effect. Chris had mentioned it earlier, but Section 232 and 301 tariffs were not affected. So we're just talking about the IEEPA tariffs. Those, as you know, they're not stacking. So if you're in the industry and you do get hit with the 232s like auto, steel, aluminum, copper, those types of products, those 232s still apply, but the IEEPA does not apply to those. And then 301, unfortunately, they can stack to 301 tariffs. I guess we'll throw in here really quickly the de minimis. That was also not part of the legislation or the executive order. So de minimis is still out there. You've probably seen the lawsuit, I believe it was FedEx, that has it going probably to the Supreme Court. De minimis is on typically parcel shipments, lower values. He had taken that away. So duties and taxes were applicable to parcel shipments. And that is currently in the court system. So just know there's more to come on that. But let's move on and talk about Section 122. So as quickly as the Supreme Court said, hey, this isn't within President Trump's power, President Trump, jumped on TV and said, yes, it isn't. That was kind of my easy way. It was my easy button, so to speak, to have the tariffs and the trade policies and work through that. But he does have full executive order under several of the sections that Chris had mentioned. But the one he enacted was Section 122, just right out the gate. It is on the 20th, he established it was going to be a 10% tariff. So currently we are seeing, as of the 24th of February moving on, your entries will get hit with that Section 122 10%. Some things to know about Section 122. Interestingly enough, it can go up to 15%. President Trump did get on social media and say that, almost immediately he was going to raise it to 15%. He has not yet. So we are still at 10%. And then it is only for 150 days that can be in place. At the end of 150 days, Congress can choose to extend that. But we do have to get Congress approval to continue with that 10%. Something Chris and I talked about earlier today, which I found interesting as well, is if he does raise it up to 15%, that starts the clock over, we do believe. So we're in this 10% holding pattern. But if he does raise it to 15%, there would be a new executive order. And so that 150-day clock would start over. Section 122 specifically states it is to address a balance of payment deficit with another country. And the reason why we put that in there is Section 122 gives the president authority to tariff if a country is in debt to us. And it has been put in effect to all countries around the world. So we wouldn't be surprised if in 8 months to a year, these also go to the Supreme Court, because it's out of his executive power to enact 122 on all countries. It should just be on countries specifically in debt to us. So stay tuned. We'll probably have another webinar in a year saying, here we go, we're going to get more tariffs back for you. Another thing to talk about is Annex 1 and 2. So there are some exclusions to Section 122. I think of 122 kind of just as a replacement for IEEPA, just so my brain gets wrapped around it. So if you have like an agriculture exemption, your 9817s, that does eliminate the Section 122. USMCA is also eliminating Section 122. So any of those rules you were seeing under IEEPA still apply to the Section 122. So specifically getting into Annex 1 and Annex 2, they are a group of products that are kind of on their own. So our Section 232, our auto, our steel, our aluminum, kind of started as like an Annex 1 and 2. So they're the products that we are currently seeing, like pharmaceuticals, that have avoided the IEEPA and the Section 122 so far, but they are now being looked at under Section 232, and it has been proposed, upwards of 100 or 200% tariff being put on those products. So yes, you are getting a break on your Annex 1 and 2 products. However, those are the lists that are going to be looked at during these next 150 days, even though it is under Section 232 or 301, which is a lot longer to get approval, because there are comment periods for importers, and then it goes to a committee, and the committee decides if, yes, these are harming the economy of the United States, and then those would get applied. So the unfortunate moral of the story, the good news is, yay, we're getting some tariffs back, we hope. But the bad news is it's just going to become more complex. So we've already started with the 122 with its limitations, but you're going to start seeing a whole lot of products get on that 232 and 301 list. So normally I'm happy news, Kristen, but today it's kind of not so happy news, Kristen. And I think, Chris, it's coming back your way.
Okay. I definitely think we should mention that trade programs have come into play here. As we've seen week after week after week, we are seeing trade programs being established with many countries. And those were all built off of the IEEPA and those duties. So we're currently looking at, we do believe the 10%, 15%. Of course, he has a max of 15%, but that 10% was because many of those trade programs that were negotiated did have a 10% reciprocal that was attached to it. So using this 10% doesn't go in violation of any of these trade programs that he's put in place, because there is a hope that these countries that negotiated off of reciprocal threat or the ability to have lower duties, that they still honor their end of these trade programs, that there doesn't have to be a full reset. And I think that is where that 10% might be coming in to play for sure. So now next steps for shippers. It is a little bit like Gilligan's Island, that we signed up for a 3-hour tour and now we're pretty much all of 2025 and early 2026, we have to relive. We have to look at all of the IEEPA duties that have been paid and decide, what's the best way for us to be preparing if there are refunds issued, that we can receive those refunds. First, importers should be collecting their entry summaries, commercial documents, and proof of duty payments. Those are all things that we know will be required for any kind of application, whether it be a protest, whether it be another process. Those things have to be supplied with those requests. eShipping clients, you do currently have access to this information in your client portals. So we are providing that, and also we can help navigate if you are not aware of where that information is located. Take note that if you're an importer that has set up with ACH payments and are either on periodic monthly payment or ACH payments that are coming directly out of your bank account, those payment records will need to be supplied by your organization, as your brokers won't have those records of the actual payment. It's important to establish the CBP status of your entries. You want to begin probably looking at the entries that have liquidated, and then work your way back to the ones that are currently not liquidated. Because I know, Kristen, if I'm correct, PSCs are currently being rejected.
That is correct, yes.
Okay. So with that being said, it's not an avenue that you can currently file. So anything that's within that 300-day period or that CBP has not liquidated, there's no actions that can be taken on it. To where protests are currently being looked at, and they're currently being held. They're not being rejected. And so those can be filed. So anything within that 180-day protest period, it's important to establish what's the first actions. It's probably those entries. Also, if you have things that have fallen outside of the protest period past liquidation, that 180-day period, you'll want to consult trade counsel. They're the ones who can file those cases under 28 USC 1581I, and they'll be able to put that in place, which is kind of like a placeholder for you with the Court of International Trade not to lose out on those refunds. And Kristen, if I had not asked you, it's right here on the slide, right? Protests are not being rejected, so we are hopefully going to be able to work with our clients. Once we receive your approval to protest, we will start working towards filing those protests. And once again, a way of putting a placeholder for if you are going to receive duties. Court of International Trade has not said protests will be the method, but we do think there must be something known by CBP that they would reject a PSC or a post summary correction, that they would hold a protest. So we're hoping that maybe that intuitive knowledge will pay off in everyone's favor. Trade Council, we should always consider consulting with them, especially depending on if you're currently dealing with things like drawback. Entries change after they're submitted. So often what the entry is once they have been submitted to customs changes through filings for drawback and drawback entries. It can change by a PSC or a post summary correction being submitted. Sometimes customs, when they evaluate and they go into liquidation, they ask questions through a CF-28 or issue a change through a CF-29. And when those changes happen, those have to be considered of what's happened to these entries in the life of the entry. And there has been over a year where these entries have went through processes. So it isn't going to be something that is simple. And the more complex it is, the better it is to involve Trade Council, because they are experienced in dealing with some of those deep, complex industries, to where your brokers, although they file these things and they make these changes, the actual legalities and the laws that apply to it are not always in their purview. So always keep that in mind for sure. We wanted to talk a little bit about how eShipping, I spoke about it earlier, but how we are able to help our clients navigate the uncertainty of this situation. We do have entry summary data, including your tariff numbers, the duty information of what you paid for each tariff, when the entry was liquidated, if it has liquidated. All of those are contained within our Power BI model. And our clients have the ability to log in, look at that real time, run reports out of that system. And we also, have our account managers who are always there and eager to help you navigate that portal, train on that portal, and truly understand what information you are able to pull and how beneficial it is to your company. Entry documentation specifically is available in our clients tracking and documentation portal. So when you log into that portal, there is a document section that you're able to look at entry summaries. You can look at your commercial invoices, packing lists, bills of lading, all of those things that help you to decide when it sailed, when it arrived, what was charged when the entry was filed. As we know, we have been through a little bit of a blender, especially poor Kristen's group, where every week, sometimes they give us a couple weeks, they change what tariff number applies or what amount applies. And each time those amounts changed over 2025, there was a new classification assigned to it. And it was used after this date, and everything before this date was using something else. And as you can tell, it's a lot of complicated information to go back and then try to track through and figure out which of these items happened in what time period, so you can establish that. So having that information right at the tip of your fingers is always so helpful. We also, in compliance and CHP, have pulled the numbers of all of our entries. Customs estimates up until December that there were 35 million entries that were submitted with IEEPA duties applying. So there's a large amount of entries out there to be reviewed. But we currently are going through our list. We're starting with the most critical. So we're looking at the entries that have already fell outside of the liquidation 180-day protest period. And we're notifying our clients that maybe they want to involve trade counsel if the money they would receive offsets the trade counsel that they would have to pay for. And then after that, we are establishing which entries are the first that need to be protested and reaching out to our customers to ask them if they would like to proceed with that process and they would like to make those protests. So those are some ways where we're proactively reaching out and trying to make sure that we're covering everyone and protecting everyone as much as humanly possible. And of course, we will continue sending out the international tariff update that contains the latest changes and anything released by U.S. government and the ongoing investigations by other government agencies. This is a great place to watch for 301 cases. Currently, there are less than 15 301 cases out there, but with 301 cases and Section 232 cases, when they are being investigated and they're being evaluated, there are comment periods where you can be heard. They can hear your voice and you can tell them how this adversely affects you or how you really support that investigation because maybe it's affecting your business in a different way. So we'll continue to put those in our international tariff update. So you know when those periods end. So you can act as quickly as possible to make sure that your voice is heard. It sometimes feels like we're a little bit powerless on how things are coming through. So a lot of these acts that are coming into play, they actually give a voice to the people who should have a voice. And so I think all of that is very positive news for us as brokers, for you as importers, and we'll continue to look for those ways to just fast track the information to protect yourself, to keep your business safe, and hopefully find ways to find money savings that help you all meet that bottom line that's so important.
Before we jump into Q&A, I did want to mention one thing, probably should dedicate a slide to it, is the ACE portal. Since January, we kind of knew there was a chance that there was going to be refunds that could be received. So Customs is asking or actually demanding that all importers get signed up in their ACE portal with ACH information. So Customs is no longer cutting checks for refunds. It's all being done through their ACE portal system with an ACH bank account information that you give. It's completely different than paying them. It's how you're going to receive monies back. So when we distribute the documents in the webinar, be sure to look out for that because you really want to get into ACE because our corrections can get rejected if you are not an ACE signed up with an ACH account in there. So just wanted to mention that. It's just so important and got to get done to get your money back. Okay, Q&A. We've had some really good questions come across, and I actually saw one that I wanted to jump on right away. It's explaining the 122 again with the agriculture exemption. Sorry that it's such a big deal and close to my heart. That is, if you are importing anything that is ultimately used in agriculture, and it falls under, it's called the Chapter 9817, that actually eliminates most of your tariffs. Your 301s, your 232 in some cases, IEEPAs, of course, and then your Section 122. So make sure you reach out to us if we're not your broker yet, or if we are, just reach out to us because that is an exemption that you should be using regardless of what tariffs there are, because that will get you, it eliminates even your ad valorem duties and taxes. Another good question, how might this ruling impact customer buying behavior as it relates to imports? due to the sheer number of companies, how might the litigation process play out? Krista, do you want to take this one?
Sure,
The buying
absolutely.
behavior.
We believe that right now, because Section 122 is less than IEEPA, and it is applying that lowest amount that was afforded to trade programs that maybe didn't apply to all the other countries in the world, that it would be a good time for shippers to ship during this period, because it would be lower duties that are paid. We do know, as Kristen has stated, President Trump is looking at using these other parts of trade acts to instate the additional duties. So shipping before those additional duties go into place is obviously a great idea. Keeping in mind always that 150-day period may just be a way to buy time to put some of these larger duties in place under Section 232 or under Section 301. Even Section 338 has up to 50% duty that can be used. So it's always that window to be able to ship and have those lower duties seems like a prime time period to really ship and fill those warehouses before something new comes down the line. We know that this is part of the political environment currently, that tariffs are a trade ability to use trade to legislate or to push other countries into falling in line with agendas that the U.S. might have. So I don't think Section 122, I don't think anyone believes that will be the end of the duties that will come. I think we all know that other programs are being used. And with the dissent, the Supreme Court decision was 6-3. The three judges who dissented did specifically state that under these other trade acts, President Trump had the ability, and they dissented, not that he had the ability under IEEPA, but that he can put the other in place. So why remove these if he's just going to go around and put them in under a different section of a trade act? So we know the groundwork is laid to use those. So it's a good time for that. And the litigation process, we know that currently the Court of International Trade has over 2,000 cases for under 1581 that are those placeholders of other companies trying to make sure they get some part of these refunds. Trade Council believes that maybe those aren't necessary, those filings aren't necessary, because the Court of International Trade is holding those. They put those to the side and said, let's get the Supreme Court ruling, let's decide how refunds are going to be issued, and then we'll start to process these cases through, because that will be, everything will be lined out. So I would say that, litigation does play a part, but maybe the majority of the litigation that was necessary for the groundwork to be laid for you to receive your refund has probably already happened and passed. The fact that they expedited the mandates to the CIT means that they want them acting on it quickly. So I think we'll see soon information from the CIT. So hopefully that answered that question.
It did. Another really good question that came across is just kind of clarifying the liquidation period. They've been told it's 300 days. I'll speak to it a little bit, and then Chris, you can jump in if I get off track at all. But so the promising thing with the refunds is you are correct. Most of the entries are still within a post-summary correction period. So it's about 300 days from release. So the majority of the tariffs that are still out there, the majority of the entries are still able to do the first step, which is the post-summary correction. Once that liquidation date hits, that's when protests take over. And then we have 180 days from protest from the liquidation date to continue to be able to protest. So most of what we have done over the last year is still in that very nice period of time where if it is ruled that brokers need to file the post-summary correction or protest, we can easily handle that. We're starting to see just those few entries back in February that might have been liquidated for certain reasons, like if a post-summary correction had already been filed, or something like that, that we are seeing it's falling out of its protest period of 180 days. Now, I believe one of the courts, I think it was a CIT, did say that they would extend that liquidation for protestability. So even if you are falling outside of the protest window, because these have been ruled illegal, they're going to extend that. So there's not going to be a lot of entries that you're not going to be able to somehow go after getting that money returned. Was there anything else I missed on that?
And it might help to explain what liquidation is, because we use these terms, but liquidation is when customs has evaluated the entry and looked at the data that's been sent, the duties that have been paid, and basically liquidation is them closing that entry and moving those funds into the commerce, or accepting those funds as the funds that were due on those entries. So although they can wait until 300 days to file or to close those or do the liquidation, they can do it much, much earlier. And we have seen them, as Kristen said, when a PSC is filed, sometimes they evaluate the post-summary correction and decide that it is at that time. They agree with everything that's entered and they will liquidate it. Sometimes someone just randomly grabs your entry, they look over it, they've maybe sent some questions, we've sent back the answers, and they say, okay, this is accepted, and they will liquidate it then. So although they have 300 days, they also could look at it 10, 12, 15 days later and still liquidate it. So it's important to watch those liquidation dates. They don't wait till the 300. It is just as they go through the process, they decide this is ready to move into the commerce. So.
And note also, this is somebody had asked a question about, do the brokers handle this? Yes. The post-summary corrections, the protest, that's something you'll rely on your customs broker for. The eShipping customers, it's something that we're already tracking. And we can give you all the information in our Power BI with liquidation dates, like anything, just so you can feel rest assured what amount of money you're getting back, how long we have to do it, kind of keep a watch on us. If you are working with a different broker, but we can still help with those. We can help with protests. We can help file protests. So they are fileable through a customs broker, but you can file it through ACE as well if you have that knowledge and aptitude in that system as well. But right now, we're very much preparing for having to correct the tens of thousands of entries that we filed over the last year. Okay,
Yes.
let's
Oddly enough, we don't receive the same funds that a trade lawyer receives, Kristen. So we are the bargain of this situation for sure. So
we are the bargain.
You definitely want us involved to save those funds.
Yes, absolutely. An interesting question that came up regarding the Section 122 and the 150 days. I had mentioned that if it goes up to 15%, the 150 days starts over. But somebody asked a good question. How many times can that happen? So Chris, maybe is it possible that he could raise to 11% and start the clock over and be that, behind the scenes of that? Or do you know much more about that? Like how many times can 122 be raised?
Well, from reading through it, if it is a match to match, it can't be continued to be put in place because it's considered a continuation. So if it is 10% on all countries, that shouldn't be able to be repeated because the amount is the same, the parties involved are the same, so it's considered a continuation. So something has to change with putting that in place. Now, are there endless options on that? Very much so, to where he could say now China has 10% for this amount of days or some kind of change in that legislation. But I don't believe, I think from what I read and what I can tell, this isn't the preferred method of putting these duties in place. It was the quickest method to put it in place. That these other options to him just require investigations and proof, and that's greater for public opinion on the administration, because then they can prove through those investigations that they are making actions that protect us, or are doing these actions have an intended purpose that is necessary. So
one question was, which I can take, is the Section 122 stacking over Section 232. I had said it earlier in the presentation, but just to reiterate, it does not. So if you are experiencing 232 tariffs, the 122 will not be applied on top of that. But it is worth mentioning, if you fall under 232 tariffs, especially for steel and aluminum, copper, you only have to pay the Section 232 tariff on the content, on the steel, aluminum content of an article. So if you're not already breaking out your invoices from steel content to non-steel content, you're going to want to do that. Note in that situation, the 232 do apply to the steel content, for example, and the 122 would then apply to the non-steel content, but technically they do not stack. Okay, another good question that came in. Our company imports on our customers' behalf. Should we as a company be setting aside money as a liability if customers begin to ask us for refunds? What do you think, Chris?
oh no, that's an interesting situation. I encourage everyone to not make any agreements with anyone regarding refunds, since we are so early into this process. We want to be careful about even acting like refunds are going to happen. That is not guaranteed. Who those belong to, what portion should go to who, and those should, that should all fall out. That's all unknown information. So really sharing that with the people asking for their portion, that there's no portion to be had right now. That until things are decided, the Court of International Trade puts things in place. There's really no negotiation that can be happening. I have heard that states have filed to have those specific refunds come back to them so they can distribute to their individual population. Once again, it's all very preemptive for that assumption to be made, and also to decide how those funds should be. I think everyone believes they have a claim in it. I paid higher prices on oranges, so does a portion go to me? We won't really know how to answer any of those questions until the Court of International Trade starts to say, these are the people entitled to the refunds, and this is the process for making that happen.
An interesting question. Should we be considering selling our claims to a third party?
I would say no. I know we've all seen the JG Wentworth, or maybe I'm just old and I've seen the JG Wentworth or whatever, that commercial where get your cash fast now. I really, once again, have to encourage everyone to be patient as this is legislated, as this is decided, and not take less than what you are truly owed. By selling those or giving those to, allowing someone else to have that, the funds could be greater, for you to as a company. And what does it look like if there's no refunds and you've sold something that has no value? It just seems all very precarious. Obviously, every company has to make the decisions for themselves that are the best decision for the company, but always encourage patience and making sure the full picture is there for you as a company to make those good decisions for your company.
Okay. It looks like a lot of the questions have been answered. I think we had someone question, what happens if the government drags its feet for the more than 2 years? What does that look like? I think Chris was mentioning earlier, we're seeing some progress with the rulings getting pushed back down to the Court of International Trade. So I don't think we're going to see that drag out for more than 2 years. It's looking very hopeful, but I can let Chris expand on that as well.
Yeah, and I think if we get like a year into the process and we kind of see maybe this isn't moving quickly or there's some concerns there, up until that 2 years, you can file that 1581I claim through Trade Council. So there's no um, real TikTok. We've got at least a year to be able to figure that out. And if necessary, that would be your process. If we're starting to fall outside of the 2 years, that 2 year limit really is on filing that 1581 claim. So if you file the 1581 claim, you are inside that protected area where when it is legislated, you're part of it. But to spend the money on that, you might want to wait until you know that that's absolutely necessary. But once again, whatever is best for your company.
I think just the last couple of questions, it's just kind of a recap, things to look out for. Of course, IEEPA tariffs, going back to that, they are still being collected. Somebody asked about the IT date. According to Customs, they are considering the IT the consumption entry, even though we don't agree with that. So we were processing or trying to process entries under the IT, and so we could avoid the IEEPA tariffs. But that is, it's the first port of entry. So even if it's IT, we still have to consider that the first port of entry. I think there's just general concern about the refunds. No, we have all the information. Your brokers have all the information when you get signed up in ACE. It's all in there. It's very clear per entry what was paid, what you're due to get back, and then the process there. We can equip you with that. I think it's a good reminder. If you are an eShipping customer, please reach out to your account manager. They're very educated on this. I've sat with them and taught them myself. So they should be able to pull up your Power BI and look at all of your entries. Any non-eShipping customer, still reach out. We can help you navigate ACE. We have some resources for you there. And especially if you do end up wanting to use eShipping as a broker to help handle your refunds, it's just a matter of getting us into your ACE portal as a notify, and then we can start pulling all of your data and analyzing it for you as well. That's about the end. Chris, if you don't have anything else to add, I just want to say thank you to everybody that attended today. I don't know that we have a really good process yet for like understanding what the CIT is going to hand us. So this will probably result in additional webinars if people are interested. But as we get more information, Chris sends out a newsletter. I know there was a couple people that were wanting to see what tariffs were versus what they are now. We have some pretty good resources for that. So we'll be sure to get that out to you guys. Chris, do you have anything else? Any final words of wisdom?
No, patience and hopefully the CIT, I believe every action that they have made seems like they do have the importer's best interest and trying to find a balance for that. So don't lose hope. Hopefully, this information has given you a little ray of hope, and always reach out to us if we can be of any help. We eShipping as a company wants to take care of you and to set your mind at ease. So.
Great. Well, thank you, everybody. Have a great rest of your day.